I'd like to welcome everyone to the webinar being hosted today by the Workers' Compensation section of the Beverly Hills Bar Association. I'll introduce myself. My name is Michael Folati. I'm the chair of the Beverly Hills Bar Association Workers' Compensation section. And this is a new and a growing section of the Greater Beverly Hills Bar Association. I encourage all work comp practitioners, as well as any other practitioners in overlapping practices like employment and PI, for instance, to get involved with the work comp section. That could be attending webinars like today, it could be networking events, or getting more involved as a section leader. I'm going to go ahead and throw my email in the chat for anyone who wants to get in touch with me to discuss the section further. Now, I also want to note that we have, in addition to today's webinar, another upcoming webinar scheduled for May 18th, and that's going to be a workers' compensation basic overview. And in between that time, on April 30th, we have a cross-practice networking event. It's located at the Rooftop Lounge at Above 60 in Beverly Hills. It's going to be hosted by the Workers' Compensation section, the Employment section, and the PI sections. Moving on, I'm very delighted to introduce our speaker for today, Kimberly Wagner, who will be presenting on the nuts and bolts of workers' compensation subpoenas. Kimberly is a graduate of Pepperdine School of Law, where she concurrently completed a master's degree at the Strauss Institute of Dispute Resolution. Her article, The Perfect Circle, was published in the Pepperdine Dispute Resolution Journal, to whose leadership she contributed as an editor. She also investigated ethical issues as a member of the Honor Board. She additionally enjoyed the privilege of a summer internship in the National Guard JAG Corps, where she participated in a program to assist soldiers with their tax returns. She has also clerked for the Orange County District Attorney's Office with the Target Gang Unit as a certified law student. And now, without further ado, I'm going to turn the floor over to Kimberly.
Good afternoon, everyone. Thank you, Michael, for that introduction. Just a little more about my practice in workers' compensation. I've been practicing workers' compensation since I was barred in 2012, pretty much exclusively on the defense side. I've been working for Bradford Barthel for 10 years, and I'm currently an equity partner and the managing attorney for our Ventura office. I also head up our ratings department and longshore division, and I've been a certified specialist in workers' compensation for about 5.5 years. Thank you to the Beverly Hills Bar Association for having me speak this afternoon about subpoenas in workers' compensation. This topic was inspired by a blog article that I wrote in 2023 and is a frequent source of discussion with my attorneys and with various clients. So let's go ahead and get started, and I will share my screen and the presentation. All right. Okay. So here's just our introduction. All right, and that's me, my contact information. If you have any questions after the presentation, feel free to email me, kwagner@bradfordbarthel.com. So we're going to start talking about just generally the mechanisms of discovery that are available in workers' compensation. To start, we have pleadings. So there are mandatory pleadings that's pursuant to Labor Code Section 5500, and that helps the parties identify what the actual issues are with an application. And there's usually a responding answer, and that will identify any particular defenses or other issues that need to be addressed in the course of the case. Subpoenas, obviously, that's what we're going to be primarily focusing on today. There are also depositions that we quite frequently take. These are governed by Labor Code Section 5710, and that includes a separate attorney's fee for the attorney of the injured worker if the deposition is requested by the defendants. There are also several self-executing discovery obligations that exist in workers' compensation. Title 8 California Code of Regulations 10635 requires parties to serve evidence no later than a mandatory settlement conference at which trial is going to be set. And it also requires defendants to provide a benefits printout upon request. There's also a subsection C part that states that parties have an ongoing duty to serve each other with any medical reports that have been received and any written communication from a physician, except where requested by non-physician lien claimants who have to get an order for those records to be released. So the goal really is to have a certain amount of discovery that doesn't have to be adjudicated and that is automatically in place to facilitate the transfer of information between the parties. The board also has jurisdiction to order a body to be exhumed in an autopsy if it's a death case. This is per Labor Code Section 5706 and 5707. It gives the board that jurisdiction to order a body to be exhumed and autopsied. And interrogatories. This is sort of a gray area in workers' compensation as to whether interrogatories are permitted and whether they can be compelled. So the original case law in this started in 1976 with the Lubin versus Berkeley East Convalescent Hospital case. The board originally stated that parties could agree to interrogatories as a form of discovery, but it didn't talk about how they could be compelled. So more recently in 2013, the board stated in the case of Smith versus County of Monterey that interrogatories may not be allowed and could not be compelled. The board sort of flip-flopped a few years later and in 2017 issued the case of Nady versus Pleasant Valley State Prison, basically saying that the trial judge erred in not compelling an applicant to respond to a written request regarding a prior medical history. So there's some discrepancy as to whether interrogatories are appropriate and whether they can be compelled. Obviously, the goal here again is to facilitate the transfer of information between the parties. So this is important because interrogatories can really save a lot of discovery expenses, saving the time and the effort of taking somebody's deposition just to ask a couple of questions about a medical history. It also provides a way to follow up on questions that may not have been answered or may not have been answered completely during a deposition without having to take a second volume. And it also strengthens the case of a defendant who may have denied an applicant's claim for refusal to provide that medical information, since it can be compelled. So the goal of the WCAB is to allow discovery in a way that best achieves the substantial rights of the parties and carries out the spirit and the provisions of the Act. This particular case came about because the board ordered an employer to permit an applicant to bring an expert to inspect the employer's premises. So there is substantial leniency to obtain information if it's thought to be important and relevant to the case. One thing that is really unique about workers' compensation law is the fact that it's not bound by common law or statutory rules of evidence or procedure. That is enumerated in Labor Code Section 5708 and 5709. The reason ultimately for these very broad exceptions is that the ultimate compromise of the workers' compensation system, which is that benefits are delivered to an injured worker more quickly through a system that is more truncated, particularly with discovery, and that's supposed to be less costly for the employer as well. But it ultimately results in potentially a more limited recovery than would ultimately be available in regular civil litigation. So we don't have things like pain and suffering. We primarily value claims based on the actual disability that a person suffers, with the added benefit of a truncated discovery. So this is why workers' compensation is the exclusive remedy for work injuries. So let's talk about what a subpoena actually is. A subpoena is an order from the court that compels somebody to be present under threat of penalty or to produce documents also under threat of penalty. So the subpoena itself is actually functioning as a court order. The purpose is obviously to obtain that information, presumably because the person won't produce it absent a court order. Obviously, if someone is going to just hand that information to you, a subpoena wouldn't be necessary and is probably not worth your time and expense. One other thing we'll talk about later too is that a subpoena is really important for the purpose of giving notice to a consumer that his or her records are being requested. So it's really important to have that subpoena process in place so that somebody knows that their records are going to be produced to another party who wouldn't otherwise have access to them. Subpoenas are also designed to allow parties to determine how strong their cases are and to really present their cases at trial. In workers' compensation, we have exclusively bench trials, so being thorough with the evidence that's being presented is particularly important. because obviously our judges are going to be subject matter experts, and they will be the sole decision maker in your case until and unless there's an appeal, and then you're obviously going to be assessed by the next level of judges on that. All right. So there is a jurisdictional threshold for subpoenas to be issued. Obviously, the court can't issue a court order if the court has no jurisdiction. So an opening pleading must have been filed with the WCAB in order for a party's power to arise in order to issue a subpoena. Labor Code Section 130 enumerates the WCAB's power and the power of its members to issue subpoenas. So if you've ever seen a workers' compensation subpoena, it's usually signed by the presiding judge of one of the local boards, and that, again, functions as an actual executable court order. All right, Title 8 California Code of Regs 372.2. And when you see reg throughout the rest of the presentation, it's going to refer specifically to this section. So this section says that the WCAB shall issue a subpoena at the request of a party. This is primarily in an OSHA context, but the Workers' Compensation Board does also issue orders for subpoenas. As I mentioned, they pretty much just have a form that's already signed by a judge that's available for the parties to use in order to issue a subpoena. So the California Code of Civil Procedure, Section 1985, and the ensuing sections is really the civil authority on subpoenas. And this is one of the really rare contexts where the workers' compensation system follows the actual rules of evidence and the rules of discovery that are used in civil court. I mentioned earlier that the board is not actually bound by those rules, but because there are no conflicting provisions in workers' compensation in the labor code and the regs, we do really default to the CCP in this particular area. Obviously, if conflicting rules were ultimately enacted at some point, they would arguably supersede the civil code of procedure in the work comp context. So one of the exceptions to requiring an opening pleading and threshold jurisdiction is Evidence Code 1158. Subsection B states that even if litigation has not been started, a medical provider must make a patient's records available to that person or their attorney, as long as there is an authorization. The provider may still be entitled to the usual $15 witness fee, and that's the fee that is normally paid to them when a subpoena is issued. They could be entitled to that fee for producing the records, along with any other expenses. There is a sample authorization in subsection H of this evidence code section. So if you were trying to get records maybe from your client for their treatment that they've had prior to litigation, you can actually do so if you have a signed authorization from them, and you can just send it to their doctors along with the witness fee. So there are three main types of subpoenas. You have the witness subpoenas, and those are used for compelling witnesses to appear at trial. You have a subpoena ducis tecum that's used for production of written documents and records. And then you have deposition subpoenas to compel the presence of the custodian of records that are sought to be produced. So when should a subpoena be issued? So we go back to CCP 1985.6C2. This requires a party who is requesting the records to demonstrate to the location that they're requesting records from that the person whose records are being requested has been notified that those records are being obtained and that they've either given an authorization or they've been given an opportunity to object to those records being obtained. All right. Regulation 10109 is the duty to investigate that is imposed on defendants. And this could be a great example of why it's important to subpoena records in the work comp context. A claims examiner has 90 days once a claim form for an injury has been produced to the employer to go ahead and investigate that claim and to determine whether it should be accepted or denied. This has kind of transformed into an argument that there is an ongoing duty throughout the case for defendants to conduct discovery into every type of benefit that could be due to the injured worker. It's sort of an ongoing debate, I think, in the workers' compensation context as to whether that is perceived as a shift in the burden of proof, whether there is an ethical violation for defendants to have to investigate and proactively, in a sense, discover and litigate an applicant's claim through the duty to investigate. But regardless, having the subpoena power is really important to execute that duty to investigate, to really look into whether an applicant is entitled to benefits, and particularly, again, initially, whether the claim should be accepted or denied. So the result of failure to investigate, including possibly, again, by subpoenaing records, is that it could result in an adverse inference. And in this particular case, the Zimmerich case, Hughes Aircraft Company versus the WCAB, the employer failed to produce material safety data sheets that the applicant was seeking in order to prove that he had suffered an industrial injury from exposure to toxic chemicals. So ultimately, the board said, we're going to make an adverse inference because the employer has access to these material safety data sheets and is refusing to produce them. We're going to infer that the applicant was, in fact, exposed to those chemicals and that those chemicals caused his injury. So it's really important to really exchange that information as it's available. If it's been requested and there's no legitimate objection to the production of those records, they really should be produced to the other side. Obviously, holding on to those records didn't do the defendant any good in this particular case. There has been some evolution of the adverse inference theory. In 2011 with the Hamilton case, they basically said, we'll still allow an adverse inference, but we are not going to do so on the issue of causation. So really, whether or not the same holding would have been reached in the Zimmerich case under the Hamilton theory, probably not. But that's sort of what the court decided to limit the adverse inference, so it's not on the issue of causation. Subpoenas can also help an injured worker prove their injury or the need for treatment. This is particularly important with a post-termination case, where producing the records of an injury that were generated prior to the termination can overcome that affirmative defense. One way to figure out where to start with what locations to subpoena for either party is to get a medical canvas or an ISO index, and I'll talk about that in a moment. You can also subpoena a non-party witness to a deposition or trial. If you do have a non-party witness who you want to appear at trial, it is a good idea to go ahead and subpoena that witness. That way you can show that you've done your due diligence to get that person to trial. So if they don't show up, you don't waive any arguments for a continuance or any further actions to compel their attendance, as long as you've taken that first step of issuing that subpoena. It's usually not necessary to subpoena an actual party to testify at trial, but it's not prohibited. So if a subpoena will not be served on a party who's expected to appear and testify, it's generally a good idea to at least send them a notice to appear no fewer than 10 days before the trial so that they know that their presence is expected. Obviously, the testimony of a witness must be material. Pretty self-explanatory. You can't just subpoena random people to be present at trial. I imagine that would be considered bad faith, if not harassment. So the materiality is important. I have had judges ask on occasion for an offer of proof as to the materiality of a witness or evidence. So it's good to know why you want that person to be present if you plan to subpoena them. A medical witness can also be subpoenaed, and this is Reg 10650. This is sort of an unusual regulation. You can serve a medical witness with a subpoena to appear no fewer than 10 days before that person's appearance is required. Live testimony, though, of doctors and medical providers is heavily disfavored by the board. The board prefers testimony via deposition, the thought being that you don't want to cause any major disruption to the doctor's medical practices and all the other injured workers that they may be seeing in order to have their testimony. So really the best practice for getting medical testimony is to do a deposition at the doctor's convenience, on the doctor's time, and that way you don't have to worry about subpoenaing a medical witness. The only reason this somewhat came up for me recently was where the medical witness was a lien holder. That might be a different situation in which it may be more appropriate to subpoena a medical witness as opposed to just their testimony on the case itself. So a couple of alternatives to issuing a subpoena. We talked earlier about the self-executing discovery obligations under Reg 10635, the ongoing duty to serve medical reports, including prior to trial, really with the idea that neither party should be ambushed going into an MSC. Everybody should know what evidence is available to potentially be presented at trial, and there should not have to be excessive discovery motions to have those documents exchanged. Labor Code Section 5710A does talk a little bit about compelling the production of records. I mentioned this code section earlier in the context of a deposition, but it also says that the WCAB can compel the production of records. And it doesn't specifically reference the Section 130 authority that the WCAB has to issue subpoenas. So the question is, does this constitute an alternative method to subpoenaing records by means of filing a petition and requesting a court order for records to be produced? For anyone who is practicing work comp currently, we know the boards are incredibly overloaded right now. So I think that's a far less efficient way to go ahead and try to get the records through a court order, probably much costlier too than just issuing the subpoena as is. So steps for issuing a subpoena. Reg 10640 says that subpoenas have to be issued on the WCAB form. Presently, we are using Form 30, which can be accompanied by the declaration on Form 32. That's for injuries occurring between 1990 and 1994. Hopefully, we have very few cases, if any, that are that old, but those are the presently used forms. And then, as we talked about, the CCP applies to work comp subpoenas. So those are primarily found in sections 1985, 1987.5, and Government Code 68097.1. And I'll go over each of those requirements on the next slides. All right. So CCP 1985 talks about the affidavit that's required to accompany any subpoena. So this requires a showing of good cause, basically that you need the information for your case. You have to talk about what needs to be produced. So again, identifying the specific information needed. You have to talk about the materiality of the items that are going to be issued in the case. Obviously, this goes to why the information you're seeking has any bearing on the issues. We talked a little bit earlier about when it comes to witnesses, you may be asked to make an offer of proof. I imagine a judge would do the same thing in determining whether to compel or quash a subpoena. And then you have to know that the witness from whom you're requesting this information actually has that information in their possession or control. And really, this is just a checklist that they want the attorneys to really consider. Obviously, you don't want to be trying to get records from one doctor from a different unrelated doctor's office. That's just a waste of everybody's time. We often see very generic boilerplate affidavits, though these should really be tailored to each location and each case if it's believed that there's going to be particular scrutiny with respect to those subpoenas. Section 1985.3b. So we've touched on this a little bit. This is the service requirement on the consumer whose records are being sought. So basically, if you're trying to get patient A's records, patient A needs to be informed that you're trying to get those records. And then patient A has the opportunity to object, or they can not object and let the records be obtained, or they can get a copy of the records themselves. The person is supposed to be informed of the request for these records before the subpoena even goes out. There's actually technically a 5-day window in which the consumer should be notified that those records are being requested before the subpoena is served. And then that subpoena has to have at least a 10-day production time. If the subpoena is mailed, it's a 15-day production time. If it's in California. That's obviously impacted by the mailbox rule. This is particularly important in the context of medical information because obviously that's HIPAA protected. So really ensuring that the person is aware that those medical records may be produced is really important. So it is obviously really necessary that the person whose records are being obtained be notified. I don't think I've ever seen an actual injured worker object. Occasionally, their attorney may object to the production of records. This will usually have to be something that supersedes the relevance of the records to the case, that entitles them to greater privacy. But we do see some of those privacies codified with things like an HIV diagnosis, or it could be a sexual history, or things like that that are automatically granted greater protection, where it's really important to protect the consumer versus just giving out those records after saying that those records will be produced. The requesting party has to provide the custodian of records with that proof of service where they can show that the consumer was alerted to the fact that their records are being requested, or else they can provide a signed authorization by the consumer to release the records. So obviously they're showing either we have given the person the opportunity to object and they haven't done so, or we have their express permission for you to go ahead and release those records. So Labor Code 4055.2 talks about specific WCAB requirements. These, to some extent, supplement what is in the CCP, but to the extent that they conflict, the Labor Code will prevail in the workers' compensation context. So subpoenas have to be served on all parties of record as soon as the custodian of records is served. I do see this as an issue on occasion. An attorney might get missed. The insurance company might get missed. So it is important to know that the parties do have to be served with these subpoenas. Obviously a due process issue to make sure that all the parties have fair and equal access to the same information. This primarily comes up as an issue, at least on the defense side, where somebody may have issued a subpoena that's duplicative of a prior subpoena that has already gone out, and it could result in duplicate payment problems or a lack of notice such that you cannot object to payment because you don't know that the subpoena was issued. It also causes a problem too, though. If one party doesn't know that this information's been obtained, it really should be fair game for all parties to use if one party has requested access to it. Regulation 17235 says that the attorney or the party requesting the subpoena is charged with serving it. So this makes sense. While the board will provide the form, the board will not actually serve the subpoena for you. The board won't do anything except provide the form, which makes sense. It's the obligation of the parties to ensure that those requirements have been met. Section 131 talks about the pay that subpoenaed witnesses are entitled to. That's for a day's attendance and payment for mileage. This is intended to parallel what a witness would get for testifying in a civil case. This was something that I don't think anyone I know in practice has ever seen, but the board itself actually has the power to subpoena a witness. We talked about that a little bit with code section 130, but they have to do so at the state's expense. So that's not going to be imputed to either party. The state actually has to pay for that witness's appearance themselves. If an injured worker subpoenas a witness, it could be held against their recovery as a lien for the expenses and the fees. This is important because that lien should really be filed before the award of any compensation if anyone besides the injured worker has actually paid for that subpoena. So it's a good practice tip to request that lien against compensation as soon as that expense has been incurred. I did have a case within the last several years where the other attorney set numerous witness depositions and then repeatedly canceled them at the last minute and then asked that we pay for it. We ultimately said, no, it's your responsibility per 131. So you need to go ahead and pay those. And I haven't heard anything since. So I think that we were correct on that one. And then Government Code 68097.1 says that basically you can do substituted subpoenas for peace officers and first responders. because it's harder to contact them at work. Their supervisors can accept service of those subpoenas. The requesting party, though, may have to fully reimburse that government agency for the cost of that first responder's testimony. So keeping in mind that that could be much greater than a regular civil witness's expenses, probably to be used sparingly with subpoenaing government witnesses. So complying with a subpoena, that's in CCP 2020.410 through 2020.440. Basically, you should send what is requested by 20 days after the subpoena or 15 days after service, whichever is later. Obviously, service, you're accounting for the mailbox rule, time for mailing, things like that. In complying with the subpoena, or responding to the subpoena, you want to include a declaration of the custodian of records and a privilege log if that's applicable. So we know that a privilege log is basically a declaration if you've removed something that's been requested because it's protected by privilege. You have to say what was removed and why, but obviously not to the extent that the contents are being revealed. The why being what privilege exactly you're claiming. If there's no privilege log, technically every document that's been requested in the subpoena should be produced, unless there's some other objection or notification to the other party that information is being withheld for some legitimate legal reason. Again, we've talked about that a subpoena is a court order, and it comes with the full force, effect, and consequences of a court order, so it's important not to ignore them. You either want to respond, object, informally respond, but they should be dealt with in some way. There are some alternatives to formally complying with a subpoena. A party can informally produce records to the subpoenaing party and then request that that party withdraw the subpoena. So there are a few benefits to doing this. Again, I mentioned that I primarily practice defense. Occasionally, we will get requests from employers to respond to subpoenas on their behalf, even though they are not our direct client. What we can do if the employer does not have their own attorney is we can informally produce those records to applicants' counsel. Obviously, the defense attorney would not complete a declaration of custodian of records because we are not, in fact, the custodian of records. And if this resolves the issue, then the subpoena can be withdrawn and everyone is satisfied that the documents have been produced. There still may be a copy service charge. I'll get into the specific fee schedule later, but there is a $75 cancellation fee generally for canceled subpoenas, so you may still incur that fee, but it's less than the flat rate of $230 per subpoena. One issue that has come up for me recently in practice that I wanted to just mention is that I'm often contacted by other attorneys who may be representing an employer on a related action. There could be a discrimination claim, harassment claim, things like that. And the employer's attorney may ask for medical records or documents that contain medical information, such as deposition transcripts. So it's important to keep in mind that these documents are obviously HIPAA protected. And because an employer is only entitled to very limited medical information, that information should really be requested via subpoena, so that the consumer is aware that those documents are being requested by their employer and their employer's attorney in that separate action. So we have to be really careful about not facilitating a huge free-for-all with respect to medical information. So types of records you can subpoena. Claims examiners have access to the internal insurance records called an ISO index. It shows prior insurance claims that have been made for things like workers' compensation claims, homeowners insurance claims, motor vehicle accidents, things like that. And those records can be subpoenaed. Oftentimes they will include a claim number and they'll tell you who the insurer was for that prior claim, and you can try to get the records that way. The reg section 10322, there's actually a correction here. This should be section 10208.7. We know the board loves to renumber regulations, so this one is now 10208.7. The WCAB has a 50-year record retention policy for most of the documents that are maintained electronically in its file. They have a 20-year record retention policy for its paper files. So if you're trying to get records from the WCAB, odds are that they exist even if it's an old file. They do have to get permission from the Secretary of State to destroy those records outside of those retention policies. So that's a good source for records as well. Medi-Cal and local healthcare agencies can be a really good source of information. If you think your injured worker has been with one of those programs, it'll tell you all the locations where that person has treated through those agencies, and you can then subpoena those facilities' records directly. One thing I know some attorneys will do is they will subpoena the medical file for the doctor they are deposing. This can get you information that was not included in their reports, such as pain diagrams, questionnaires for medical exams that were completed by the injured worker that may not have been produced to the parties. It also gets you their billing records. We had an unfortunate instance once where a doctor produced basically evidence of fraudulent billing in response to a subpoena. So it can get you unusual information you may not otherwise expect. You can also get personnel files from concurrent or prior employers, CalOSHA files that can be helpful for a 132A claim. You can subpoena anybody potentially who has subpoenaed you. If this other entity believes that you have relevant information for their claim, chances are that they also may have relevant information to your claim. So paying attention to whose records you're subpoenaing can be really helpful too. And then x-rays. This is actually also Reg 10660. X-ray films are subject to subpoena and inspection by a requesting party. Things to consider when you're issuing a subpoena. Things like aliases, different dates of birth. If you know a person has used different names or different dates of birth, which you can obtain during their deposition, it can be helpful to include that information in your subpoena so that you can check all the variations. Again, one of the requirements with the affidavit, know specifically what you're looking for. Make sure that you're being as specific as possible with the subpoena. I generally think it's okay to use a pretty boilerplate explanation, but to supplement it with very specific things that you think that location may have that are helpful to you. In getting first responder records, this has been one of the bigger challenges I have faced trying to get records from a police department, sheriff's department, fire department, whomever. They don't normally maintain their records using the names of the parties involved in those incidents. So for those particular records, it's good to have the date, the time, and the location of whatever incident you're trying to get records pertaining to. So just some practice issues that have come up for me at least, with dealing with subpoenas. Multiple subpoenas issuing for the same location. I had this recently come up in practice. An attorney was alleging that even though we were serving him with these consistent treating records we were getting, that he never really knew for sure whether he had the complete medical file. Ultimately, there was a compromise reached. The judge helped the parties meet and confer. But what an applicant's attorney may want to keep in mind is that the copy service may not get paid where there are multiple requests for the same location under Reg 9982E1. So whether or not they'll hold the attorney liable for payment if the defendants don't pay, I doubt it, but there is that possibility the copy service won't get paid where that issue comes up. Some providers will ask for a signed authorization, and they'll say, I won't produce the records until I get this very specific form signed by the injured worker. They're not allowed to do this. A subpoena is, in fact, a court order. They have to comply with the subpoena. They can't make up their own rules. They can't make up their own requirements. The best way I've found to get around this is to just let them know, this is a court order with which you are refusing to comply, and have your court or your copy service may be able to kind of work with them and get the records from them. Ultimately, if they refuse to comply, you can file a petition to compel and you can request costs and sanctions. But I think it's important to at least make that effort to get the records and to let them know how important it is to comply with the subpoena, as at the very least that'll constitute a meet and confer effort. This is another issue I ran into recently where I had a provider that I subpoenaed produce redacted records. And it was very clear from the context of these records sort of what was removed. And we kind of had an idea of what they were taking out. It turns out that it was information related to a medical episode a person had suffered during an arrest. So obviously medical information pertinent to the injury they were claiming. I filed a petition to compel compliance with that subpoena. And I made mention that this information was highly relevant to the case. Ultimately, we got in front of the judge and she kind of said, I agree with you, you're entitled to that, but good luck enforcing an order to compel against a law enforcement agency. Fortunately, I was contacted by their attorney shortly thereafter, who actually, to her credit, apologized and said they shouldn't have been redacted in the first place. And they did ultimately provide the full version of those records. So having that information and really just pushing back if you get an inadequate response from a location and informing them of their obligations can really help make headway in getting those records. There are some limitations on California subpoenas and the authority to enforce a California subpoena. CCP 1989, obviously we're limited to state lines. There's only subpoena power over witnesses who are physically within state lines. Though with respect to getting those records, there could be some workarounds, which I'll talk about on the next slide. If the records have been sealed, it is best practice for a party, even if they're trying to protect those sealed records, to object to the production of those records. Because in the end, if the records are considered to be potentially relevant, a judge may order their production to him or herself to review in camera to decide whether or not they're sufficiently relevant to the case to be disclosed or unsealed. And if there is some information in those records that is relevant, but other parts of it are too prejudicial, the board can also limit or redact what portions of those records will ultimately be produced for use in the workers' compensation system. I mentioned that there are some workarounds to CCP 1989 with the jurisdictional limitations. There is the Interstate Depositions and Discovery Act. So this is basically, it's actually kind of interesting. It's related to the Uniform Commercial Code that, the section that a lot of states have enacted with respect to contracts and things like that. There's a similar movement now with subpoenas and discovery. This particular act has been enacted in all but 4 U.S. states and territories. It is still pending in Massachusetts, Missouri, New Hampshire, and Puerto Rico. It's basically a proposed process for getting subpoenas across state lines. The way that this works is basically to issue the subpoena in the state that you're from, so California for us, which is then translated into a new subpoena under the jurisdiction of the participating state in which you're trying to get those records. And then that state can serve that subpoena. The act doesn't seem to distinguish between witness and subpoena ducis tecum. So I imagine it would be effective for pretty much any type of subpoena that you're trying to serve. Personally, I've never used this specific act, but it's good to kind of have handy if you need to. And you also want to keep in mind, too, that if you're requiring the presence of a witness, that might be an expensive ask if you have to transport them across state lines. Federal agencies also tend not to respond well to state subpoenas, and many of them require individual authorizations. This is for locations such as the Social Security Administration, the VA, the military, places like that. The quickest way to get those records is to have your injured worker or your consumer sign a release for those records. In most cases, I've had judges want the injured workers to participate in those authorizations and that discovery. So if you have someone who's uncooperative, a hearing might be helpful. And then the copy service that you're using should be able to just take that authorization to the agency. And they should also be able to help you figure out which authorization you need. One quick tip on those authorizations: you want to make sure that the authorization signed by the consumer or the injured worker is in the language that that person speaks. But you also want to provide a copy of the authorization in English to the agency so that they know what that authorization is for. Okay, so if you get a certificate of no records, what's the next step? The declaration of no record, the declaration for the custodian of records has several options to check off for why records may not be available that have been subpoenaed. Oftentimes it's an issue that can be corrected, so you may be able to reissue the subpoena if you know why the records haven't been produced. I've had good luck following up with my copy services to kind of work with me to see if we can get those records produced. So there may be options if you get a certificate of no records. If a location refuses to comply, what is your next step? Labor Code Section 132 says that the Superior Court may step in to compel compliance, and they can actually take contempt proceedings to the location that's refusing to comply. My preferred way of compelling compliance with a subpoena is to file a petition to compel with the WCAB. This is much cheaper and I think much more efficient. A lot of the times it will result in the cooperation of the location, so it's not necessary often to go through the process with the local superior court. Obviously, that can get very expensive, time consuming. You're working with another jurisdiction. It's going to be a little bit more difficult. For me, usually the reason that locations don't respond is because they're not at that address. There's no forwarding. They're out of business. They just basically don't exist anymore. And if that's the case, then even starting contempt proceedings may not be helpful to you to get those records. So I think that's a remedy to be used very judiciously. Objections to subpoenas. So we're going to talk about some reasons that a consumer, a provider, or a location might want to object to a subpoena. The first being unreasonable violation of privacy. So this primarily I've seen in the context of other people whose information may be in the records. I have a lot of work with medical facilities. So the injured worker was working in a medical facility and we're trying to get their personnel file or some kind of records pertaining to their work at that facility. It's really important for the names of patients that they're working with that may be in those files to be redacted before that information is produced. That is obviously protected. It could also be an instance where another employee was disciplined or involved in an incident. That information, if it's not directly relevant to the applicant's injury, that may need to be redacted. So just keeping that in mind that there could be privacy issues in those records. Information is protected. So we primarily see this in the context of financial records. There is case law from 2013 that says that that information may be ordered to be disclosed. Generally speaking, just as a routine matter of course, the person's tax returns are not going to be made available. That's considered an unreasonable invasion of privacy, a breach of protected information. You can't just go and request tax returns for every single injured worker. That being said, there may be instances where, well, basically what the court talked about in the Hoagland case is that if there's a greater public interest in having a policy of requiring disclosure of that information than protecting the consumer's privacy, they will order production of that information. A lot of the time we see this in an instance where a person may be running a business and they're trying to hide their earnings or they're trying to just not produce information that really should be produced. And it's not necessarily an individual's privacy that's being protected, but it could be like a business or something where the records are less intrusive. So that's usually where we see that issue. Information is not relevant. I think this is kind of a difficult argument to make in objecting to a subpoena. We all know, the shoulder bone's connected to the knee bone, to the toes, everything is related to some extent. There's an argument that can really be made that a lot of different body systems and body parts are connected. Treatment for one thing could be relevant to treatment for another. A lot of the times, too, you'll get doctors who are saying, it's important for me to see all the information. It's up to me as the medical professional to decide what's relevant. So this may be a more difficult objection to sustain for a subpoena. I had a case somewhat recently where a subpoena issued after the closure of discovery. This was one where we were set for trial, and after trial, the opposing counsel issued a bunch of subpoenas for records and said that they wanted to have those entered into evidence because they didn't have them before. Part of the problem that they had, though, is that they didn't realize that I had already subpoenaed those records and we had sent opposing counsel copies of those records. They hadn't limited their subpoena, so there was no indication of why those subpoenas had to be issued after we were set for trial. So being mindful of when you're subpoenaing records and your discovery posture when you are issuing those subpoenas is important. It is not appropriate to quash a subpoena solely because you don't think you're responsible for paying for it. Really, an objection to a subpoena should go to the legal right to obtain those records. So basically, you can't block the records being obtained simply because there's an argument that that subpoena shouldn't be paid for. A good example of this is Labor Code 5307.9. It basically says that if there is a request for records to the defendants records are not produced, a subpoena can issue at least 30 days after that letter. So basically, applicants' counsel has to make a good faith effort to get those records from defendants, and if not, then a subpoena can issue for defendants' records. It's not appropriate for a defendant to say, well, you're not entitled to subpoena these records because we already produced them. Well, no, they're entitled to those records and that content, obviously, because you've already produced it. Rather, the better remedy for that is to just issue an objection to the copy service and say, 5307.9 says that you don't get paid for this. Yeah, you did the work. Sorry, it's not compensable. So there's a distinction between the legal right to obtain the records and whether or not there is liability for the expense of obtaining those. Standing, a non-party may object to a subpoena. Again, this has to go back to one of the legally valid reasons to not produce those records. I think this would primarily come up in the context, like I was saying earlier, of like a personnel file. If somebody knows that there's information about them in a personnel file that's being subpoenaed, they may have standing to object to that subpoena and the production of those records. Okay. So after there's been an objection to a subpoena, it's a good idea to meet and confer, figure out what exactly the issue is. I know a lot of judges will set petitions to quash for hearings. There's an expectation that the parties have met and conferred and tried to figure out what exactly the issue is. And the subpoenas may be amended to account for those objections, sometimes with the judge's assistance there too. If there is going to be a petition to quash, CCP 1985.3 says it should be filed within 10 days of service, and it should be produced to the witness and to the copy service. So basically, you're giving notice, a heads up to the location. Hey, we're objecting to the subpoena for your records. Don't produce them. And this is because compliance with the subpoena is usually demanded within 15 days. So you obviously want to let everybody know, cease efforts on getting these records, don't produce. There's an issue that needs to be worked out first in court. If it's really, really important that those records not be produced, it could even be appropriate to do an emergency order to stay. Procedurally, this is done by doing a walkthrough with the presiding judge. It is a very quick process. Basically, you have to give the opposing side notice by 10 a.m. the day before you plan to walk it through with the presiding judge. As I mentioned, some judges are now automatically setting petitions to quash for a hearing, so it may not be necessary. But if you think that the location is going to produce the records or the copy service is going to keep following up with them and they might ultimately get the records, it may be necessary, particularly in a case where those records really, really need to be protected. Okay, and whether or not a petition to quash is actually the correct procedure, even if you do have a valid objection to the grounds for the subpoena, the CCP actually suggests that an objection to a subpoena is sufficient. You don't need a formal motion to quash. Personally, I think it's better practice to do the actual petition to quash because now you're actually requesting the order. You're requesting an action on your objection. And I think that's just a better way to go about it because you do have that mechanism. All right. So if there is an improper objection to a subpoena, sanctions may be imposed against the party who requested the protective order but was unsuccessful. This is in the CCP. Likewise, a party who unsuccessfully attempts to compel records can be sanctioned. And then in the labor code, there's 5813, a catch-all sanctions provision for unreasonable conduct. I imagine there'd have to be some kind of unreasonable aspect of the arguments in a case like this where sanctions would be issued. So we've got to be careful with that practice of compelling and quashing. Touched on Labor Code 5307.9 a little bit earlier, that those records have to be requested from defendants at least 30 days before they are subpoenaed. Again, this only affects obligation to pay. It doesn't affect entitlement to records. And that's in Section 9982. Section 9982 also describes circumstances where no payment is required for subpoenas. So again, if this is why you're opposing a subpoena, a petition to quash is not the right remedy. You should do an objection. I mentioned the scenario earlier with the repeated subpoenas. 9982 specifically says that those are not compensable. Summaries of records are not compensable. WCIRB and EDD records are not compensable if they're otherwise available. I have found lately it's been more difficult to get records from these locations, so I think it may be more reasonable to subpoena them. IMR records is another really big one that I've struggled with lately. I get a lot of subpoenas for IMR records. Those are not payable under 9982. And then a cancellation due to an order to quash the subpoena, that subpoena becomes non-payable. And then more than 4 certificates of no records after July 15th, 2022. So again, these are objections to payment, but not necessarily to the legal entitlement of the requesting party to those records. The fee schedule for subpoenas is in 9981. I'll go through that on the next slide. They are stuck with a very specific fee schedule. It's helped with a lot of payment disputes and to streamline that process. We talked about the witness fees that may be required under Labor Code 131. I've also been seeing more locations requesting additional charges if they maintain records off-site or if those records are burdensome to obtain. So there could be additional charges that are requested along with the regular fees, which are under 9981, you have your flat rate of $230. This is effective July 15th, 2022. That was an increase up from the prior flat rate of $180. We have our cancellation fee I talked about, $75, cert of no record, $75, additional sets and all that. For a copy service that is requesting payment, the invoices must have certain information that I have enumerated on this slide: declarations, identifying information, tax ID numbers, copy and registration numbers, things like that. I have not come across any statutorily defined consequence for not complying with providing this information. I suppose you could argue that it's not a valid bill, and therefore, until a valid bill that complies with these requirements has been produced, there is really legally no charge for those subpoenas. But otherwise, I'm not aware of any authority that says that they just don't get paid because they excluded a billing number from an invoice. So Section 9981, I mentioned, is the fee schedule for subpoenas. Payment should be made or disputed within 30 days, or there will be a 25% penalty. This is potentially conflicting, though, with the Labor Code, which lays out the explanation for review process. I'm going to talk about this in a moment. I do think that this section is preempted by the bill review process. So I haven't really seen this section asserted in order to recover that penalty or the 30-day requirement. Okay, so ensuring that you preserve your objections to the subpoenas is important, or preserving your objection to payment is important. A copy service will never be entitled to payment in excess of the fee schedule, but obviously that doesn't include penalties or interest that could potentially be owed. So it's important to assert those arguments if you do plan to make them. It just shows that you're not just ignoring a bill, but that you're actually paying attention to have a legitimate legal defense. When payment is being requested, Labor Code 4603.2b says that the itemized request has to be made within 12 months of the services. This goes back to, I mentioned all the things that have to be on their invoices. So if that's submitted without those things, is that an actual valid invoice within 12 months? So the administrative director was supposed to enact rules for how things were supposed to be submitted, what was supposed to be submitted above and beyond the actual itemized requirements in the bill. So this argument may or may not be enforceable to bar a request for payment by a copy service if it's made more than 12 months from the date of service. And keeping in mind too, the statute of limitations to file a lien is 18 months. So failure to provide timely notices if 4603.2b is strictly enforced, that may preclude all remedies, even filing a lien, even though they're within the time to file a lien. So I haven't really seen this code section used much. I think that it kind of conflicts with some others, but I'd love to hear stories about how that they have helped somebody. All right, code 4625A, bills for med legal charges are barred if they're not timely submitted. This talks about the 12-month requirement again, but whether or not that is enforceable, whether we have the proper structure in place from the administrative director to actually submit that is kind of in question. The copy service that I talked about earlier, that was set up by SB 863, applies to payments by a copy service, whether they are requesting payment as a med legal provider or a lien claimant. So obviously they're getting paid the same amount regardless of how they are classifying their request for payment. And I'll get into the distinction of that momentarily. So defects and subpoenas do not invalidate payment if the records were actually obtained and if the subpoena was actually executed. Although there are certain burdens of proof that copy services have to meet in order to recover that payment. And I mentioned earlier that subpoenas do have to be served on all parties, but it doesn't invalidate the requirement to pay unless the failure to serve was prejudicial. So that's another requirement. Labor Code 4622, this is the section that talks about payment to med legal providers. When an invoice is received, there must be an EOR issued, an EOR being an explanation of review, issued within 60 days that complies with numerous requirements. I have those in a couple more slides. They're kind of dry, so I'll skip through those. But it basically says what all these things have to be in that explanation of review. And this kind of goes back to what I was talking about with Reg 9981, right? So issuing an EOR within 60 days is obviously not consistent with issuing payment or disputing within 30 days or be subject to a 25% penalty. As I mentioned, I think that the labor code would preempt the reg to the extent that they're inconsistent. So I have seen the EOR process control with these kinds of issues. 4603.3 talks about the explanation of review process. It has all that information that has to be in there. That is also enumerated in Reg 9794C. Talks about the difference in what needs to be in the EOR depending on whether you're just disputing the amount or whether you're disputing the entire charge. This is something that hopefully the insurance administrators know what should be in these EORs and that they're compliant with these particular requirements. So Reg 10786, when an EOR issues, the provider, and in this case we've been talking about copy services, has 90 days to object, or else they will be deemed to have waived all objections, and the payment that they have received will be deemed to be final, even if there is an issue with the explanation of review complying with 9794C. If there's an objection regarding the amount of the payment, they have the opportunity to then request a second round of review with an explanation of review within 14 days of receiving their original explanation of review and payment. If there is no payment at all, the defendant should file a DOR and a petition for review within 60 days of objection. If they fail to do so, the provider can file the petition in the DOR. Going through this particular avenue for a copy service is more common. We see it more commonly than filing liens. because it is less expensive. We know there's a $150 lien filing fee, but there's also no statute of limitations on a petition for a non-IBR determination. That basically means that there is a dispute as to what needs to be paid that's above and beyond the amount of the payment, but it's actually regarding entitlement to payment at all. All right, so paying for subpoenas, I've kind of touched on the two options that a copy service has to collect payment. There's the med legal aspect under 4622 with the process I just explained with the explanations of review, the petitions for non-IBR, or going the lien route. So to the extent that the copy services are considered a med legal provider, there's no need for them to file a lien. They can go outside of that process and do what I just talked about. The advantages being that there's no statute of limitations if you're claiming you're a med legal provider and you're going to go the direction of the non-IBR route, and there's no filing fee. The disadvantage is that there's potentially more work. They have to file a petition, they have to request a hearing, and potentially there is a higher burden of proof to show that you're a med legal provider. All right, so the board retains jurisdiction up until and unless the only issue is payment. So we do have the IBR independent bill review process where basically there's a third-party arbiter of what the actual value should be, basically interpreting the fee schedule amounts that are appropriate and what needs to be paid, strictly speaking, sort of like medical billing, coding, stuff like that. It's very technical. So thought to be, let's give it to this other agency, sort of like independent medical review, to take that burden off of the judges and the parties. Additional defenses to payment for copy services. If there's no WCAB jurisdiction over the claim, and that's the ultimate decision and that's the conclusion and termination of the case, from like some affirmative defense, lack of employment, statute of limitations, fraud, no dependency in a death case, things like that, those could defeat a claim for copy service records or a claim for WCAB jurisdiction over payment to a copy service. So I'm going to talk really quickly about what the burden is on a copy service that's asserting that it's a med legal provider. Basically, they have to show that there is a contested claim, that their records are being used to prove or disprove. This is a relatively low burden, in my opinion. There is usually going to be a dispute, and we talked about earlier with the opening pleadings, you have your application and your answer that outline the disputed issues. So long as the information is relevant to the case, it's very likely it will go to one of those issues. Many defendants open a case contesting at the very least nature and extent of an injury. So if the records go to the nature and extent of the injury, it's highly likely that those will be considered med legal expenses. And with the Martinez case, subpoenaed medical records are presumed to be medical legal, which makes sense because those go to the contested claim often again of the nature and extent of the applicant's injury. If everybody agreed on what the nature and extent of the applicant's injury was, you wouldn't be at the board. So this just talks about what the when the contested claim exists. This is basically when there's entitlement to a benefit that is being rejected by the employer, or there's a failure to admit liability, or the employer fails to respond to a demand for payment of benefits. A disputed issue arises, a contested claim arises rather, and that if you're getting records that go to one of those issues, that will be considered a contested claim. So again, it's any issue which pertains to the applicant's entitlement to benefits. The records do not need to actually have been used to prove or disprove a contested claim. They just have to have been obtained for that purpose. So realistically, those records are pretty much always going to be used for a contested claim. I suppose if your subpoena doesn't talk about that contested issue, maybe there's an argument, but generally speaking, those will be considered subject to med legal. And an application alone is not evidence of a contested claim, right? So if you have an injured worker claiming an injury, the defendant may or may not be contesting it. The parties are in court and the case hasn't settled yet, but that could just be a matter of time. It's not necessarily because of a dispute. So that is one thing to keep in mind. A copy service can't just produce the application and say this is evidence that the claim is contested because it's before the WCAB's jurisdiction. Additional hurdles for a med legal provider. The services that are provided must be reasonable and necessary. This, I think, really pertains to requests for additional sets and why those additional sets were requested. So this could apply, for instance, to an attorney who has subbed in and they're getting duplicative subpoenas of the records the prior attorney may have subpoenaed. We know the state bar rules say that when you substitute out as an attorney that you should produce the file to the client and or to the new attorney. So it's not permissible for that new attorney to just restart discovery and incur duplicate payments for discovery if that information was already in the prior attorney's file. And there's no requirement that an industrial injury be found to claim payment. So I talked a little bit earlier about a lack of jurisdiction, which is distinguished from a lack of an industrial injury. So if the board has no jurisdiction, that will include over the copy services request for payment. If the board has jurisdiction but finds no industrial injury, there will still be liability for those subpoenaed records because defendants are responsible for paying discovery costs. So it's sort of like with the med legal report. If the med legal doctor finds no industrial injury, the defendants are still responsible for paying that med legal doctor for the services rendered in that case. They can't just say, you found no injury, therefore we're not going to pay you. That would be a pretty dumb strategy. So, and then for a certificate of no records, this is still considered to be proving or disproving a contested claim. Obviously, you thought those records existed, assuming you complied with the affidavit requirements from 1985. So that certificate of no records is still relevant to whether or not that contested issue or contested claim existed. And a request for records has to be initiated by a party or by its representative. And basically this goes back to the only people with standing to request records in an action are the parties themselves. You can't just have some random witness or somebody insert themselves into the action and just start issuing subpoenas willy-nilly. The context in which I've seen this come up is with copy services who will get records without them actually being requested by an attorney. They'll offer to just start subpoenaing random locations. Really, that's not appropriate without the explicit authorization of a party or that party's attorney for that specific list of locations that they're getting those records from. So it's important to have that connection that there's actually a party or their authorized representative directing the discovery and going forward with that discovery. All right. And there's my email again. I have not been checking the questions, so I don't know if there were any. And I don't see any. So that concludes the presentation.
Alrighty, this concludes today's presentation. Thank you so much, Kim, for an excellent presentation. And thank you so much to our audience for joining us today. Have a great day, everybody.